The only charge pending against Mark Torrey Jr. is aggravated assault as a third-degree felony with the special allegation. But according to his attorney, Jay Arriola, if the government intends to charge Torrey with negligent homicide, a new indictment or a preliminary hearing is needed, and the government must present the new charges to a grand jury, including evidence that was not suppressed by the Supreme Court.
Actually, as a practical matter, he's not even been charged yet with the new offenses because we have to decide the motion to amend and whether or not it's going to go back to grand jury. But technically, as it stands now, the convictions were vacated, and although he remains under the court's jurisdiction, our position is that the bail conditions should be modified.
Arriola requested that Torrey's house arrest be lifted and that Torrey be released on a $5,000 personal recognizance bond, further requesting that the $250,000 property bond for his pretrial release be returned, pointing out that since 2017, Torrey has not violated any conditions of his pretrial release. Torrey was found guilty of negligent homicide and third-degree aggravated assault, both with the special allegation of possession or use of a deadly weapon. He was acquitted of murder, manslaughter, and second-degree aggravated assault. Winning his appeal to the Supreme Court, the convictions were overturned, and the case was returned to the trial court. With a second trial now in the works, Arriola says that the indictment against his client must be modified to avoid double jeopardy. The Office of the Attorney General disagrees, arguing that the proposed indictment does not allege any new or different offenses. It simply modifies the degree of the charged offense in the initial indictment, reducing the charges of manslaughter to negligent homicide, with the special allegation as a lesser included. The AG contends that Torrey's rights will not be prejudiced by this change, citing that a reduction of the charges and change to a lesser included do not substantially change the ability of the defense to offer evidence or prejudice the defendant, pointing out that the Supreme Court did not dismiss the case, but instead vacated and remanded it back to the trial court. While Arriola cited to the court that the language of the statute relative to indictments state that it can be amended at any time before a verdict if not charged with new offenses, he says that Torrey has the right to a grand jury indictment and that it's not appropriate under the plain language of the statute to include an additional offense and a different offense in the indictment by amending it, citing that the case is back to square one, bringing into question whether this means that there is no charges pending as opposed to square one with the initial charges.